Okay, we're gonna call the disqualification subcommittee to order. Mr. Vogel, will you do our roll call, please?
Certainly, Mr. Chair. Ms. Dawson? Ms. Dawson? Mr. Geffen?
Present.
Mr. Urban? Mr. Urban? Ms. Kaser?
Present.
Judge Kulik? Judge Kulik? Mr. Page?
Present.
Representative Robbins? Representative Robbins? Mr. Sandoval?
Here.
Thank you. Ms. Sherlock?
Present.
Mr. Tatum? Mr. Tatum? Mr. Chair, 5 of the 10 members are present. Unfortunately, a quorum is not present, or 1 shy.
Okay, and as we're going to continue with the meeting, and we're not going to be making any formal votes on anything, but having a discussion, which I think is just fine. And I said before all of you got on, everybody gets a gold star for participating today. We appreciate you guys rolling in on a dreary day. So hopefully this will just raise our spirits. We won't go, Mr. Vogel, why don't you, we're not going to adopt previous meeting minutes, but will you kind of give a quick overview of where we're headed in the next 6 months? We've had some discussions about what this is going to look like moving forward, just in terms of timelines, deadlines, and so on.
Certainly, Mr. Chair. So I guess for the next 6 months, I'd like to point out the next 9 months to start with. So the statute that enabled the task force requires that it turn in a final report no later than December 16th. And so just thinking about timelines and how long it'll take to sort of hash out what sort of language the full task force would like to use, and then writing up the report, potentially writing proposed statutory language. I'd kind of suggest that groups like this subcommittee would want to get their work done, I think, by September, and deliver recommendations to the full task force, then have some time to chew that over and work up the text of the report itself. So that is about 6 months from now. So again, that's just a suggestion, but I would suggest that the group might want to think about how I'd like to use that 6 months, perhaps come up with a goal for each of those months that it would like to meet, something like this. I suppose, continuing that line of thinking for that last month or so, potentially I might suggest that goal be to work up the actual language of the suggestions that you'd like to make to the full task force. That's essentially what I've got. Just sort of a heads up that our time is not endless.
Yeah, it sort of felt like once we passed that first moment, we were just on cruise control. So I think it's a good reminder that we still got a lot of work to do, and just a little bit of a discussion about where we've talked about going next. Our bigger meetings are going to continue to be educational. We're starting to book people with brain science of juveniles. Starting to have discussions about who to bring in, kind of victim side, county attorney side, and so on. And then in the subcommittee, one of our goals, I think, starting today, is to try to figure out, we had those sort of broad thoughts as part of the interim report, and we've received a bunch of data. And our goal, I think, with the data is understanding that not everyone enjoys looking at. I'm looking at a 68-page document of data, and it's a heavy lift for everybody to have to do all of that. How can we best use the data subcommittee to take the data that they've received and find ways to tell us about it and analyze it? So specifically, I'm just looking at it. I see in 2019, there were 20,000 individuals who were disqualified. It breaks that down and so on. So our goal today, and I'll get to Mr. Page in just a sec, is to start coming up with questions essentially about the data. And I've heard from several members that no one wants to sit and analyze 68 pages, and that's just one data set. So what can we task the data subgroup with interpreting the data? So before we get any further, please, Mr. Page.
Well, I was going to have a suggestion to that end, Mr. Chair, but if you're just outlining what we're going to be doing, I can wait until it's appropriate.
Maybe we'll get to it just a second, just ask any kind of general questions about that. And so like the idea, like we're talking about juveniles, one of the things to look at is how many individuals have disqualifications based on an adjudication delinquency. And what, that's a pretty easy one to identify. But I think, some of these subsets are, broken down by race and other things. What questions specifically should we task? And I think it could be just very broad, but trying to come up with some work, quite honestly, for the data subcommittee. Not that they've got a lot of data. What should they be doing in terms of extracting it to getting to us? Because I think anything that we put forth with a recommendation to the legislature needs to be backed, I think, with data. And how can we get that data? What data supports an argument we're making or a recommendation we're making? What doesn't? We can also add some anecdotal stuff, but the goal, I think, is let's find a common sense way to merge data with recommendations.
And I think, John, that was kind of what, one of the questions, like, I think that the data subcommittee had was like, if you all are talking about disqualifications for juveniles, like that's something that you all are interested in, can't you just look at the data and pull that out of there to say how many juveniles are adjudicated and pull that data out yourself? Or is that something that so that back to Josh's point about marching orders, like now that we've collected the data, do you all just pull what you need out of there? And so like, I think there's just some clarity that we need.
Right. And I think I think maybe it's a bad example to just talk about the juvenile adjudications because it's on page 28 in big bold numbers. But I think there's other more subtle forms of data that could be put together. For example, how does the adjudication of delinquency, how does that weigh out when we start looking at any kind of disparate impact? I haven't done the numbers on any of that, and I probably am not going to. Because I think there are some basic things we can pull out, but there are a lot of things. Truthfully, I don't think we want to spend the time. I don't think as a subcommittee we want to spend that much time, because I think there's some people that aren't going to be able to have that kind of devotion and dedication, and that's and the data subcommittee is sort of at this point where like they've gotten the data and they really don't have that next round of tasks, and I think the goal is to give them some tasks.
Yeah.
Are there any, like, just in very broad terms, are there any kind of questions about that? Yeah, Mr. Page.
I would just have a suggestion, Mr. Chair, of the data that we should look at. I do have the 2018-2019 data overview that was sent out to the group, but that does not include variances and set-asides and how frequently those are granted by, and that to have those numbers broken down by crime or whatever way is going to allow us to make decisions about what crimes should be disqualifying or not, I think would be really helpful. When we were passing the foster care licensing reforms, I recall receiving that data from DHS, and it helped guide those conversations, and it wasn't the determinative factor.
Yeah, we're still waiting on that data set. So it's a good question on variances. I don't know. I don't recall if the variance component was requested. And I don't know, and maybe Ms. Kaser and Ms. Sherlock can identify, can you request a variant? I mean, because a variance in my world is always employer driven. In foster care, how does that work? Who's requesting it then? Because there's no employer technically.
And Ms. Sherlock, I think, was about to hop in, Mr. Chair. My understanding is the subject of the study would request the variance. So the individual who's applying for foster care would do so. But Ms. Sherlock can correct me if I'm wrong. And to answer your chat question, Ms. Evans, I don't know that I still have that data. I can go digging, but I can't promise that.
It would if you find it, that'd be great. I still think we need kind of the broader scope stuff from DHS, and we've been promised it, but it has been a while. And I agree that it is another level to determine, how things are working. With this most recent, I'm going to make sure I am right on the pages, but 77 pages, I think, or 78. I think there's a lot of stuff in there. It just takes some work sometimes to extract. And, I think it's going to help with any narrative, even really kind of basic information. I think there's been some concern about the 15-year disqualification for individuals with drug offenses. Well, how many people are we talking about? I mean, I think that's a really helpful number, that it's not some de minimis number, something like 6. I mean, we're talking about significant numbers. We have a little bit of a small group here, but are there some issues that, without sifting through all the data, that you would like the data subcommittee to kind of dig in a little bit more and provide numbers and a narrative? Yeah, Mr. Sandoval.
Yeah, so I would be curious to know, like my particular situation, which, is, I'm not alone in that. I have a felony domestic on my record from when I was like 19 years old, and, I'm 33 now. But I'd be curious to know, all of the different data sets around not only my particular charge, but just I think even from a broad scope, like you're saying, like what are the different charges? Because that'd be a good question. Like what charges? Like I want to say mine is like a permanent bar, and I believe there's like things on there that are not a permanent bar that it's subject to opinion, but would be a worser charge or less socially acceptable charge. I don't know the right how to word that, but but there are things on there that someone could get a set aside after a period of time, whereas I couldn't, and it just doesn't even make sense. So to just I think maybe evaluate them all, generally speaking, or maybe like the top 5 or top 10, or I don't know. But I know I care about my situation with having a felony domestic. I've been rehabilitated, I've been clean and sober. That's long time ago, and I was under the influence. Particularly, I was under the influence. So I also have a special interest in drug charges and just anything in that realm of category that would be valuable to know, and
Yeah.
And and I don't know if I'm beating a dead horse by saying evaluating the items that are in the different timelines that they have, but then also I know our goal is to find a solution of what does that look like when we identify some of these things. What does that look like? Are we going to refine the review process? Are we going to change those exact crimes to I don't, that I'm curious where that goes.
Okay. I mean, so I'm looking at the data set now, and I think it's a great request to what are the top 5 by year permanent disqualifications, and then really the kind of the percentage. So if we're going to talk about, the ones that, because so in 2018 there were 533 disqualifications that were permanent, and in 2019 1,191. And then some of the numbers are real low. Some of them are less than 10, and
Mhm.
we got an assault that's 238 of them were assault, aggravated robbery 216, crim sex 5, 111, and then a lot of small numbers.
Yeah,
Domestic
and
assault 76. So would
mhm.
that be helpful, do you think, to kind of know what are the main permanent DQs? What are the main, like a ranking?
Yeah, and I would even suggest, and not to put more work on our plate, because I'm with everyone in regards to trying to understand the data that I'm trying to read. But I would even almost say, like maybe top 10, because if there are some that are fewer, I just think that data might be relevant still, even if we decide to
Agreed.
move away with it, if we determine that. But maybe good to evaluate 10 or 15. 10 might be a solid number.
I like 10 a lot. I was thinking on the permanents because there's just not as many. 5 made more sense, but I think you're right. Does anybody else have a thought about that? Ranking and then with percentage. I think that would be helpful. Just if we're going to talk about the most impact, looking at which ones the most disqualifications.
Hey, John, like having a thing, I just scanned through this and I can tell you the top 2 right off the top. And so this is super helpful for me to have some direction. So thank you for doing this.
Okay. Oh, my pleasure.
I was just
Ms.
going to
Patriot?
add a comment. So I think the percentage is always nice, but it's also nice to know what the N is, because a percentage can sometimes look, low. You go, oh, it's only 3% out of how many though? So sometimes I think we also have to think about in the context of like, how many people are we actually talking about here? And I like the idea of putting kind of a ranking. I think to kind of go with our narrative, if we could do kind of a drill down of those top 10 too, how many were based upon they were adjudicated delinquent? Was it based on a preponderance of evidence, or was it based upon a conviction? Because that's all kind of out there too. And I did some preliminary kind of looking at some of them, and there's a story there, I think, of how many were convictions and how many ended up being because, a preponderance of evidence or not. And, interesting, that check forgery comes up pretty high on some of those, the 15-year DQ, I think. I think it was based on preponderance of evidence, if I looked at it, maybe.
Yeah, it's a great question. So, like you can almost do it both ways. So you could do it like, okay, what are the top 10 offenses? And then I think some work on just the numbers, like ranking the numbers. So for 2019, you got 20,000 disqualified. And I have to remember if this one's individuals or background studies. And then kind of ranking it. Okay, you got 13,000 convicted, which means you have this essentially 7,000 people who are never convicted of a crime that are disqualified. That's a pretty high number in my brain, although I know that some of them have due process with maltreatment and involuntary termination. Alford pleas are pretty low, but admissions 3,100, adjudications delinquency 1135, and the preponderance of evidence 831. can someone else kind of hold my hand through how we might want to ask the data subcommittee to compile those breakdowns? Yeah, Ms. Sherlock, please.
I'm not sure it's getting exactly at your question, Mr. Geffen, but I'm also curious. I think I breezed through the data when we first received it, and I believe that it talked about how many variances or set asides were approved, but I would be curious to have that breakdown per crime. Because, for example, and this is the reason I'm asking, I think Tiffany, you just mentioned check forgery. Was that what you just said? Like that's a crime that's on there. Of the check forgery, and we had to do requests for reconsideration, how many of those ended up with a variance? So were 100% of the times somebody was convicted or there's a preponderance of evidence about check forgery, were variances granted? Because I think that can help us decide maybe which of these crimes we can take off of a list that requires such a variance versus crimes that are maybe like an assault type, or where there's concern about physical safety, which I think would be a harder variance to get at times. So I would be curious to see that kind of breakdown also. I don't know how deep into the
so if we're jumping into the abyss, what about multiples? Like we have multiple disqualifications.
So one might be more serious and one might be less serious.
I'm just trying to figure out how you compile data, because, and I know there's a chart on this, and maybe Gina has it. It's how many disqualifiers there are, and DHS did a presentation that said, of the disqualifications, the vast majority are 1, 2, or 2, I think, and then it steps down. But how do we? Because I think it's a really, really good point, Mr. Sherlock, and I'm just trying to think how we get there with that. And is that data we've requested, Gina?
I do have that chart that shows like how many disqualifying crimes people have. But I don't know.
You want to? Could you share it? We'll just
you guys keep talking and I'll bring it up. Yeah.
Talks amongst yourself, kind of thing. Okay. Because I think it kind of goes back to what Mr. Page is talking about. If we can identify those ones that are all getting set aside, why are we even jumping through this nightmare? And I think for them, for DHS too, that's a lot of work. And if we could take those off the top, it would make sense for everybody. Is that fair, Mr. Page? Kind of.
It is, Mr. Chair. That is the reasoning behind the proposal that I had set forth.
I mean, one of the things I'm interested in too is, I mean, we've identified the disparate impact, but having somebody put together some more thoughtful narrative data in a paragraph about what this data says about what is the disparate impact on these laws to our communities of color. So that's one I'm thinking of and would love people to weigh in on that if they agree or disagree, of course. And I know Mr. Page has his hand up, so it might be on something else, but please.
Slightly different, but something that the data subcommittee might be interested in looking at. These are broken down in the document I have into the amount of time for which someone would be disqualified. I'm wondering if it might not be valuable to break them down or reorder them and into categories of conduct, such as violent felonies or drug crimes or crimes of that imply someone wouldn't be able to handle money, for example, and seeing if there are any patterns that emerge in that area, and also might help frame what crimes we would still want to keep or get rid of in rewriting the statute.
Do you think, following up on that, Mr. Page, that it gets difficult to define a crime of violence?
Mr. Chair, the legislature does have a statutory crime or list of crimes of violence. That is one way that could be done. I would also just leave it to one could leave it to the discretion of the data subcommittee that is full of really smart and thoughtful people, and maybe not even asking or prescriptively telling them or proscriptively telling them, these are the categories we want them broken into, but look at these and let us know what you think the appropriate categories are.
And
That makes sense.
the other hard part about that, Max, is that in Minnesota, drug crimes are considered crimes of violence, and it has to do with the gun laws. And if people want me to talk a little bit more about that, I can, but they're woven together. So how would we fix that,
I think Mr. Page is right too. We can come up with whatever definition we want, I think, as long as we say what it is.
Because it's civil and not criminal, right? Because we're over here on the civil side.
No, I just think that, just because the legislature defines something as a crime of violence doesn't mean we have to use that exact same definition. We could, put an asterisk or footnote saying, we're for this analysis, a crime of violence are these offenses.
Okay.
And then, because my experience with the statutory definitions, it's too broad, and it doesn't strike me sometimes and going, oh, that's violent. But I think what Mr. Page, I think he's right. We can come up with a different definition.
Got it. Will has the chart.
Okay, and I want to get Ms. Kaser. Do you want to hold on, or do you want to? Okay, why don't we do the chart and then we'll get to Ms. Kaser. Yeah, that's the chart. And along Ms. Sherlock's, because I don't know if we've asked for it, but like we could ask for just the first two, because I don't think we need to get into the weeds on 6, 7, 8, 9, and 10 disqualifying factors. Gina, do you know if we've asked for those broken down? Okay.
No, and I'm not on mute. And I am very concerned about us asking for more desegregated data, because we have a lot. And so
I think that makes some sense too, is we haven't really gone through everything, all the data we have. And I think the fear is that we'll just keep asking for data and we'll never get to analyze it. It could be on our wish list. Thank you for sharing though, Mr. Vogel and Ms. Kaser.
So I was just going to come back to you, kind of were asking about how to help build that pathway towards looking at let's say, adjudicated delinquents. How do we create that narrative? So I think by looking at those top crimes, again, that kind of stick out, and then how many were because they were adjudicated delinquent. So pulling that number out and in a comparison might be a helpful way to look at that. An example I can give is I'm looking at the 2018 data, so page 20 of 78, and controlled substance there was a total of like 746 that were, there was a DQ. And I'm looking at the 15-year disqualification. And 231 of those were at admission. That's what it was based upon. 15 was because they were adjudicated delinquent. And then only less than 10 was preponderance of evidence. A majority of them, 400, almost 500, were because of conviction. But I think that admission sticks out to you a little bit. Like, we DQ'd for 15 years because someone admitted that they had possessed a substance,
and
potentially.
I believe those admissions were probably a part of some sort of court proceeding, and that they admitted but were not convicted, and they were routed through a diversion program or some other program. So it would have been an on the record admission, as
Mm,
opposed to going to, NA and admitting that you were using chemicals.
Right.
Yeah, we asked for a definition of that, and they were if I remember correctly, Will help me with this. They were a stay of adjudications or stay of, what's the one where it drops off your record or whatever. It was those ones.
Yeah.
Mhm.
That's how I've always seen it. When I've looked at them, you look at the underlying criminal case, and that's what you find is some admission on the record, because
Mhm.
that's what you're scouring for. You're like, did they admit? Because some agreements are you got to admit it, and some don't, which can be problematic. Every now and then you'll get an admission where the department had used an admission in some other proceeding, the family court proceeding, something else that just sort of popped up.
Mhm.
But most of those are going to be in court under oath. Yeah, Mr. Sandoval.
Yeah, and that I can personally relate to that because I was 19 years old and that was the same kind of situation I was in, where they were just saying, plead to this, we'll let you out, stay adjudication, don't do it again. But I was still stuck in my addiction. And so, yeah, I can personally relate to that point.
And I want to be clear, this is personally, that I think a lot of people that admit things didn't do those things, and are not guilty of those things. So I think it's very common for people to want to go home, want to be with their family, and the fear of something else, a legitimate fear, brings them to that. So I believe that fervently. So just because there's an admission, I'm not saying, I just think it's hard to undo, but I'm not saying
Right.
it's real.
Right. And so then that's the long-term effect, right? Is now they have a 15-year disqualification because of that. So that's, again, that kind of gets to the story a little bit, I feel like. And it'd be interesting to look at it from just that adjudicated delinquency mindset and even the preponderance of evidence too.
Yeah, and you have significantly different rights as a juvenile than you do as an adult, because we're not creating a criminal record. It's a different process. Yeah, it's troubling. Gina, is your hand up? I don't want to cut you out, but I didn't know.
Yep, it actually is. So just getting down that, we're talking about the data questions and, for you, Max, looking at those 6 or 8, really heinous crimes that the risk of harm is so high that we're just not willing to take the chance. And then, what are the other crimes as we look at this data that after a bar where we wouldn't, like right now, the way that it stands, like, for a, first degree possession charge or, even a financial charge or whatever, you have an opportunity to go before the commissioner and ask for a set aside or whatever. What are there other ones, like say in Leo's situation, or a robbery or something that somebody committed at 19 or whatever, that we would think as community that after a bar where they couldn't ask for a set aside at all, they're barred from asking for a set aside for, say, 10 years, that we would say, okay, now you can come back, and after a certain period of rehabilitation, we would maybe consider your application. Is there another list of those crimes that you all as county attorneys or maybe the judges would maybe consider after a certain period of time? And then and then maybe some that we would be willing to take off. Because I would love to start having those conversations in this group. Because there are so many, and there's like looking at the data, you know, second degree assault with a deadly weapon is one I would love for this group to really, data aside, I would love for this group to really take a look at, because it's another big one. There's a couple hundred. I can see 75 in 1 year, and then whatever it is on the larger year. And I've talked to 20 of those people where, you know, it probably should have been charged out with it as a domestic. Like they got into an argument, and, you know, sometimes the weapon is, you know, they brandished a weapon, but it was actually words that were used. Nobody was actually even hurt, right? And so, you know, after a certain period of time, we don't even let people plead their case after they've been rehabilitated. Like, how does that keep community safe? How is that public safety that we don't allow people that have been rehabilitated to ever work again? And so I would just, you know, how do we protect community for a certain period of time and then allow folks an opportunity to, you know, commissioner can still say no.
Let me ask one quick question, Gina, and I'm not trying to, I'm not disagreeing with you at all. Is remedies looking at that though? Because they're looking more at the permanency question.
So, and here's my point in that, yes, but Max isn't on that. Judge Kulik isn't on that. We have a bunch of people saying, rah, rah, yes, let's do all of these things. We don't have any opposition on there, and it's problematic.
Okay. Okay, that makes a lot of sense.
So that's why I'm asking Max, like, specifically, like we need somebody in there, or somebody to come present in there, or I don't know what that looks like, but I'm asking for help right now.
Mr. Page, you think maybe just sort of offline we could talk about a couple of the issues that the remedies group is going through, just to get you and some of your broader group involved, because I think what Ms. Evans is saying is right, that maybe they're not getting some of the other side of the argument in their group, and we want to make sure that it's not, you know, we're waiting until August before we have an earnest discussion on that.
Mr. Chair, I'm happy to meet with that group and attend those meetings if my schedule allows as well, whether it's one time or multiple times. Also willing to talk offline, but if Mr. Vogel wants to send me invites to the next meetings, I can certainly try to do that.
And
even if you could come a couple times, Max, that would be awesome. It would just, like, I feel like I'm the only person pushing back a little bit in there, and we need to have a balanced discussion.
Yeah, if the world is you're the one pushing back, then we need to get another group in there. And I think, Mr. Vogel, if that's going to be happening and Mr. Page can identify those times to come, I think it's really important that Remedies understands that he's carving out time, and some of those specific issues should be raised during those subcommittee meetings, just so we're not wasting anybody's time and we're maximizing Mr. Page's expertise and involvement.
Certainly, Mr. Chair, and I'll be sure to consult with Chair Dawson about.
Yeah, specifically around permanency, right? So those when Max is there, we should be utilizing that time to talk about the permanent list.
I would assume too the preponderance of evidence is pretty high on remedies, and you know, we've danced around the POE issue, but it is within remedies right now what their recommendation is on preponderance of evidence. Gina, do you agree, or are you?
I do.
Okay.
100%. Yep, 100%.
Either you were squinting at an email that popped up, or you were giving me a crusty.
Nope. I was reading something. I'm getting old. Ben has his hand up. In response to my squinty eye, Ben has his hand up.
Oh, thanks for. I didn't see that, Ben. Please.
Yeah, no problem. This was back in response to discussion about the states of adjudication and admission disqualifications. Just from an MDH as a reviewer perspective, we're getting more cases, or maybe I shouldn't say more, but there are often cases where the judge's order on a stay of adjudication tries to say something where this stay will not have an impact on your licensure or your employment opportunities, or it's not going to be put on your record. And everybody enters this agreement with that understanding. And then DHS does not need to adhere to that order based on 245C. And so what we see is, in many cases, I shouldn't say, well, in a good number of cases, those people are going back to the court and amending that guilty plea and stay of adjudication into a continuance for dismissal. And there's an interesting kind of interplay where a continuance for dismissal is almost the same thing, where you're kind of under oversight for a couple of years and aren't supposed to do anything bad, but they don't result in disqualifications, where these stay of adjudications that, you know, would get similarly deleted from your public record do result in the disqualification even after the stays are completed. And I know there are some amended procedures from DHS where some stays they don't disqualify for them anymore after they're completed, but it's not in statute to do that. So just wanted to bring up the disparity between those two very, very similar agreements that courts enter with people, and just throw that out for the group.
I mean, and one of the hard parts too, Mr. Hanson, is, you know, if an individual gets the really beneficial stay of adjudication and still has to enter an admission, as opposed to something where they would have gotten a stay of imposition, they would be better off for DHS terms if they get the stay of imposition and the case is reduced to a misdemeanor later, because then instead of having the 15-year admission disqualification, they just have the 7-year misdemeanor disqualification. So it gets really weird.
Yeah.
And, you know, I mean, in my opinion, the people that get the stays of adjudication are the people that are showing something significantly where the court isn't as eager to burden them, and the prosecutor doesn't feel that the individual needs to be so burdened with the conviction, yet our background study law treats them exactly the same. And I think it's really confusing for people as they go through the process, thinking they don't have a conviction, but they're going to have a 15-year disqualification. So it's a problem.
Also and it also has the impact of then when they request reconsideration, they request it to challenge the correctness as well as the just the risk of harm factor. And the correctness puts it on a 45 business day track. So it doesn't get addressed as quickly as if there's just a reconsideration or risk of harm reconsideration.
You just blew Gina Evans's mind.
Sorry, Gina.
So then it just it takes longer then.
Yeah, it gets kind of pushed a little lower on the priority.
Because it's less of a priority then. And then, do these people not understand we are in a workforce crisis right now?
We're doing our best.
Oh, wait, you are these people, aren't you, Ben? Sorry. My bad.
We fully understand the circumstances.
My bad.
I want to bring us back to, in case anybody has any more ideas that we can just, even broad issues that they want some more clarity on data, because our goal is really to help the data subcommittee figure out how to allocate its time with all these numbers. I think we've gotten some really good things, but I want to make sure that we at least, and of course, if you come up with something later, reach out. But is there anything else that people want to have some I mean, you know, I think just talking about some of this today was really helpful, looking at those assault twos and 72 preponderance of evidence cases on assault two it was surprising to me. Mr. Page.
Thank you, Mr. Chair. I don't know if this would be beneficial or not, and there are a lot of different crimes included in here, but you know, it may be worth considering the presumptive prison sentence, if any, for these crimes, and practically speaking, if someone is convicted of one of the crimes, if they are likely not able to be able to be employed, if they're being incarcerated, that is, for an extended period of time, or what the average sentence is. This may require accessing information from the Minnesota Sentencing Guidelines Commission, and it may be more work than it's worth doing. I suspect it might, but it would be interesting to know, as well as, the data that exists that probably isn't in the subcommittee's hands, but the likelihood of recidivism based on the crime. The Sentencing Guidelines Commission shortened the maximum sentence for a number of crimes to 5 years recently, and the practice in Hennepin County is 3 years, because the data suggests that 3 years is the amount of time that passes before someone typically would no longer recidivate. So that's kind of a broad area, but it may help inform decisions that we would want to make for disqualification periods.
Yep,
if you think-
absolutely. Ms. Cassane, we asked about that in the data subcommittee a while back, or one of them. Have you heard back about any information about people license revocations or set asides that were granted and then people had to get pulled for egregious performance at work? If that was data that we could get pulled, do you remember us asking about that?
Madam Vice Chair, yes, I'm working through the list of requests and working on asking about the fourth data set, but I'll get you that information as soon as I can.
Okay.
The other thing I was thinking about, and in this case, I see your hand, I just want to comment on this, is the expungement statute, and how the expungement statute has this idea of waiting periods, and that if an individual recidivates, then it re-triggers the waiting period. I wonder if those numbers, the expungement statute essentially has a 2, 4, and 5 year waiting period after the completion of probation, that if you don't have a subsequent offense during that period, for the most part, you're eligible for an expungement. Not everything is listed on the felony side, but I think it further, lends to Mr. Page's idea that there is this idea that after a certain amount of time, you're less likely to recidivate. Ms. Kaser?
Thanks, Chair Geffen. The other wondering I had, and probably goes with that ranking a little bit, but how do we start to maybe eliminate crimes or look at the crimes that don't have a lot of disqualifications? And maybe a guiding post, or I don't know if it's a comparison, is we had that 2008, I believe, report, and they had some recommended kind of ones to eliminate. And can we use those and look and see, like, well, how many people are still disqualified for owning a spring gun or whatever it is, I think is one of the crimes.
Yeah.
To see if that's, again, something we could look at starting to reduce or cut down on some of these crimes, or indecent exposure or something, whatever it might be. So trying to look at some, and maybe as you categorize some of those different crimes, that would help lend to which ones maybe are kind of low-hanging fruit we could remove.
Ms. Kaser, what do you think about the fact that some might be very serious but have very few disqualified just because it's not charged a lot? Looking here, even under the permanent list, all we get are less than 10. But like arson in the first degree is less than 10. But I don't think anyone's saying we should take first degree arson off. At least maybe people are. But how do you? Just because something isn't charged a lot, does it mean the person doesn't have
someone might not be disqualified a lot for that particular crime, but it might be a serious crime still. Absolutely. But yeah. And I don't know how you would maybe rank that a little bit too. It's almost like, how do you rank the crime, the seriousness of the crime? But they're seen as all the same right now in the present statute. So how do we start to eliminate or differentiate. That's why I went back to that 2008 report, just because
Yeah.
they already did maybe a little bit of that analysis.
I agree.
So,
And again, back to somebody, first degree arson, for example, like somebody did that at 17, and you all have an opinion about that, right? That at 30, they should have an opportunity to be set free from that. Well, what if they did it at 18 or 19? So then no, first degree arson's a serious crime. They shouldn't have an opportunity to, like,
But-
at 40.
I think there's a difference between whether there's a disqualifier or whether or not a person has a right to seek some set aside at some point.
Permanent. Yep. I'm talking about
yeah.
permanent stuff,
Yeah,
right?
I was just
And I'm
looking.
looking at this list right now, and some of the stuff that's on it, like indecent exposure. And yeah, that's serious, but forever?
Agreed.
Like,
And I think some of the question is for us is the recommendation going to be to remove the permanent disqualification or readjust it? And then let's say it's not, then are we also, or alternatively, going to recommend certain matters be removed from the permanent list? You know, they're kind of two really separate ideas, but I think we should be prepared for both. And I think the large group should decide how we want to do that. If we want to make alternative plans, or we say this is what it should look like. Mr. Page, I have an odd question. Since you're our resident prosecutor, do you think there could be any world where we get rid of admissions as disqualifications?
Thank you, Mr. Chair. I am a creative thinker and can imagine such a world. But however, it doesn't sound like a likely outcome legislatively to me.
Okay.
That's just my gut instinct reaction,
Yeah.
but
not in 2023, it's not.
yeah.
Just seems like there's a lot of problems from that you almost wish people could get the benefit of that bargain, where especially with stays of adjudications or cases that are, you know, somehow continued with, you know, once they've completed it, it's no longer something that could be viewed, because you can get an expungement and successfully do it. But I think the problem is rich people get the expungements, and a lot of our, you know, poor and oftentimes communities of colors don't. And
Is that
that's
part of
what hurts.
the thing they read to you at sentencing? I know they read that this can impact your immigration status and all of that stuff. Is that part of the thing that they read at sentencing, that this sentence can impact your future employment?
In my experience, there's not a lot done. I mean, more now than ever, but there's no requirement that collateral consequences be discussed. There's no issue. I mean, most judges in my experience don't have a discussion about these issues at all. And like, I think what was talked about before is, like, you know, a lot of people don't understand this. Even on the defense attorney side, you know, we get tons of calls saying, like, if I do this, what'll happen? What if I get the judge to say you shouldn't use it for this? Well, I think as what was discussed earlier, it's not really controlling.
I think, Mr. Chair, I do think you could, rather than getting rid of admissions entirely, I think you could build in language that would likely be more palatable, that an admission creates some sort of presumption, or might change the evidentiary standard, or shortens the window before, you know, cuts in half the disqualification period or something like that. But I think politically it would be difficult to remove those as a category.
Yeah, I appreciate your candor and thoughtfulness that I lack, because I just, Yeah, it's just something I always struggle with. Well, we've only have 2 minutes to go. And I would admit that I'm still struggling with a teacher strike in Minneapolis. We have 2 kids enrolled, and I'm going to be running at 5 o'clock with one of them somewhere. So are there any other things before we end the meeting for today? Anything from you, Mr. Vogel?
No, Mr. Chair, and I can pass along the discussion that you had today to the data subcommittee, although I mentioned you'll also want to have a discussion with Chair Williamson tomorrow.
I think we should do that. If you could start to put something together that kind of goes over those talking points, and I think we want to fine tune them a little bit. I had a couple thoughts, and then we'll get them to the chair of the data subcommittee and then distribute it to the rest of this group. So in case we got something wrong, we can
Yep.
have your expertise, everybody.
John, and then if we could just have a conversation about what those data meetings could look like, because just in the time we were talking, like I was able to go through, like we could have working meetings with the data subcommittee. And that would be awesome to spend those hours every couple of weeks actually digging into the data. So.
Okay. Maybe we'll talk in our meeting tomorrow about how to best do that. I think, data is so easy to not dig into. That's probably a really good idea. Okay.
Okay.
All right. Well, I think we're adjourned. Thank you, everybody. We will see you.